Good to have you back, and many thanks for sticking around to Smart Means Business. It is a good morning from us to you. It is time for our business insight here this morning as we continue to have discussions. And this time around, our insight takes us deep into understanding what is within the various provisions and the various recommendations from members of parliament in relation to the Employment Amendment Bill 2022. Good to have you, like I did mention. But before we go into our kind of discussion today, remember to grow your investments with the Zabo platform. *292# is the USSD code that you need to use to kickstart off your investment. And with Zabo, which is a platform by Autox East Africa, it is making it more possible for you to invest in government bonds and other securities. The minimum amount of investment is just 15,000 Ugandan shillings, and you are good to go. And you'll be able to grow your investments with the platform. The market opened at 8:15 a.m. and their closing time is 3:15 p.m. East African Standard Time. You should note that these markets are fully closed during the weekends and on public holidays. Zabo, my money, my future, Autox East Africa says, do something new. And well, we're back to our topic of discussion this morning. Like I did mention, we're taking an insight into the Employment Amendment Bill of 2022, how it does impact those already in the employment sector, and what recommendations do the members of parliament feel should be added in relation to this. Now, joining me this morning is Robin Kagoye, who is the executive director, Voices for Labour. Good morning, and many thanks for joining us.
Thank you.
Good to have you on the show today.
Thank you.
And it's a brand new week, and I do believe for the people in the employment sector, this is one of the most hectic days of the week because it's the weekly startup. Before we even go deeper into our discussion, kindly say hello to my viewers for them to know deeply who we have this morning.
Hi everyone, I'm Kagoye Robina. I'm a labor and employment lawyer, but I'm also the executive director of Voices for Labour, a civil society organization that promotes accessible justice to workers.
Okay, and many thanks for joining us once again. Ms. Robina, if we are to look at Uganda's employment, I would wish from your own perspective, what is the entire outlook of our job market or our labor sector currently? Okay,
so out of the over 40 million Ugandans, we have about 23 point something million working Ugandans, the ones who are employed. But of this working population, the employed population, over 87 in the informal setup, the informal sector, or they don't call it a sector because there are so many sectors, but it's now an economy, they're in the informal economy. And we have a very small portion that is in the formal sector. The informal economy is the one that is characterized with deregulation. These are workers who are working not in formal arrangements. And the biggest number of those who fall in the informal economy are actually what we call self-employed or on-account workers, and they constitute over 73%. And then the small portion that falls in the formal sector, those are the workers who have found themselves in who are working for formal enterprises, but also under formal arrangements. They have written contracts of employment. One of the things you should note is that you can actually work for a formal enterprise but still be categorized as a worker who falls under the informal economy, especially when, for example, you're working as a casual laborer without a formal contract or a formal kind of arrangement that defines you as a worker. Also, you know, you're talking about the outlook. The general outlook is that 3/4 of our employment, our workers, they are working under what the statisticians
are putting out there. Yes, whether it's happening on the ground or
yes, but according to the UBO's statistics, they categorize it and they give it a term called vulnerable employment. So they say 3/4 of Ugandans in vulnerable employment.
Okay.
So, and vulnerable employment, they go further to define it as the one that is characterized with low wages, lack of social protection. Yes, that's why the statistics, the
3 out of 4.
yes, no, 3/4. So, definitely, it's just work that is not decent work.
Okay.
And actually, according to those statistics, over 66% of Ugandans are working under oral arrangements, and only 33 point something have written contracts. So that's the outlook.
Which clearly shows that we really need to look at most of things in here. Looking
Yes.
at the issue to do with contracts and, you know, this level of appointment in regards to the way people are getting jobs in one way or the other. What do you think the issue is? Do you think it is because of a setup that we were used to, or something that we really need to put through the law? Because when you look at the contracts, at times most of the contracts we have are verbal. Regardless of the kind of company you're working for, most of them are not written contracts.
Yes, but you see, I don't think we should say that it's something we should just get used to.
Okay.
But one of the ways of promoting decent work and also economic development, because decent work actually promotes economic development, workers shouldn't really work under informal arrangements. They should have written contracts of employment. You see, workers become more vulnerable when they work under verbal terms, because if I employ you by a word of mouth, the next day can actually terminate you by a word of mouth,
Because
and yet you have
job, yes,
and yet you have legitimate expectations as a worker. You've because of your employment, you undertake so many responsibilities. You have so many expectations. My child is going to this school. I have rent to pay. Because of your employment, there are so many other obligations that come. So if you're employed by a word of mouth, it is actually very easy to terminate you by a word of mouth without notice. So contracts promote a certain kind of security for workers. And that security also is not only at the workplace, but it can also make them access, for example, credit. How are you going to access credit from the banks if you're just employed by word of mouth? Who will believe you that actually you're working?
Very true. It becomes very rare. And well, when you look at the other issue here, amongst the proposed amendments, the Employment Amendment Bill of 2022, there is Clause 1 of the Amendment of the Employment Act 2006, which highlights something to do with definitions in the appropriate order. And the key highlight here is the domestic workers. And I want us to, look at our domestic workers and the conditions they work under in this country. I think the domestic workers are what we can term as the shamba boys and maids, or mainly the maids, really.
Yes.
Do you think in any way the law has been able to protect them?
The Principal Act, first of all, the Principal Act does not didn't cover domestic workers.
Okay.
Actually, they were under the categories of employees who are not regulated by the unemployment relationship.
Okay.
So the amendment seeks to bring domestic workers also in the ambit of the unemployment relationship, because currently domestic workers face so many challenges. They're also merely employees. They leave their homes to go into another home to provide their labor. So they need to be protected. Of course, there have been some issues there, especially in when you're talking about definitions, but also it brings us to the definition of a workplace, where previously a workplace did not include homes.
Yes.
But it's an amendment that is coming in good faith to promote the rights of domestic workers.
Okay. And well, when you look at some of the outlook of what the members of parliament are recommending in the bill, what are some of those key provisions or changes that they want to be introduced, and how do you think they are going to be impactful or helpful to our employment sector?
Okay. One of the changes, first of all, we talked about casual labor.
Yes.
In the Principal Act, casual labor is just defined, but there's no particular provision that really talks about casual labor. Yeah. It is only in the employment regulations now, I think under Regulation 39, that prohibits an employer from employing someone on a casual basis for a period of 4 months. So the regulations require that after 4 months, such a person under a casual arrangement should be given a written kind of contract. In the new amendment, the current bill proposes actually 6 months. It proposes that it prohibits, first of all, an employer from employing work on a casual basis for a period of for more than a period of 6 months. So after 6 months, that worker should have a written kind of a written employment contract. Though in its form as it is, I still feel that is not a clause that may really work so much for workers, because when you're talking about the outlook, I didn't talk about, for example, the new forms of work on the market. We have new forms of work that are cropping up, like that's actually rampant, not just cropping up, like outsourcing, subcontracting, and temporary agents work. Now, if you have a provision, for example, that that tags protection to a qualification period, for example, of 6 months, that I can work for 6 months under casual terms. Yes. After 6 months, now the employer has a choice
to either make me a serious professional
or even let me off.
Okay.
So now what happens, for example, with agents work, where we are having, if you've seen recruitment agencies that supply labor to different companies, like Q-sourcing, like Job Connect.
Short-term contracts.
Yes, the short-term, they provide those workers. Mukwano can say, we want these workers in this kind of department or this production plant. We want maybe 1,000 workers or 500. And then Q-sourcing recruits those workers, gives them, sometimes may even give them a written contract of employment, but may not actually give them. Okay. Since now the law gives me a window to employ someone for 6 months. Yes. So I take them to Mukwano. Mukwano wants them for 3 months or 6 months. And after 6 months, I take them again under the same casual maybe arrangement. So, of course, there is a window which says if an employer terminates me after 6 months and again I'm re-employed, they'll be continuing to have service. But it's very tricky. I still feel that is not strong enough. Employers can still play around with it. After 6 months, they can exchange workers and say, okay, these recruitment agents bring me this kind of workers to continue promoting that kind of arrangement. And then the other amendment, the Bill 6, to provide for is on sexual harassment. Okay. Yes. Now, previously, the employers, the Principal Act requires that an employing entity that has more than 25 workers should have a sexual harassment policy in place. So the Principal Act tries to put that obligation to only employers that have that kind of number. There's still that qualification kind of. But we have employers who are having less than 10 workers. So what happens to those 10 workers? Don't they also need a framework where they can be protected from sexual harassment? So the amendment actually now removes away the requirement of 25 employees. Okay. So everyone who is employing another has a duty to protect that person from sexual harassment and has a duty to have a policy in place. Okay. The other thing I would comment on the clause of sexual harassment that is still not protective enough, especially when it comes to the scope of liability. Okay. The scope of liability for sexual harassment cases tags liability to only senior managers, the senior supervisors, someone who is, it talks about an employer's representative, but a representative who has authority over the worker. But actually, even a fellow worker can sexually harass a fellow employee. Yeah. But also with these kind of indirect employment relationships, for example, where there's outsourcing, where there's agents work, what about that kind of indirect employment? What about when the managers, for example, if Q-sourcing has sent some workers to Mukwano and the managers of Mukwano harass that worker, who among those employing entities is going to be liable for sexual harassment? Because in law, first of all, there is unemployment relationship tagged. Most of these recruiting agencies now retain an employment relationship with the workers they supply to go and work in workplaces that they don't even actually control. So when their workers get sexually harassed there, who is responsible? So that sexual harassment should not, the scope of liability should expand to even indirect kind of employment relationships for it to be more protective. But also the amendment does not address sexual harassment on accessing employment, because actually sexual harassment in most cases
happens when someone is seeking for a job.
Yes, exactly. It starts
on
from there.
That if you want the job, you have to offer something.
Exactly, but it only addresses sexual harassment during employment. But what about access?
Okay.
There should be a measure on access.
Also that you believe should be something added onto it. Now,
yes.
My other issue with the issue to do with casual employment, because this is a new clause that is also supposed to be added into here, whereby a person shall not employ another person as a casual employee for a continuous period exceeding 6 months.
6 months, yes.
Like you did mention.
Yes.
So that means with this new provision, it's more like if someone works for you for 6 months, if you want to stay for them, if you want them to stay with you,
you should give them a written contract.
Okay, not verbal.
No, you should give them a written contract, and they should have the same benefits as those workers that already have written contracts of employment.
So that means they will be protected by law.
Yes.
With in regards to this same
Yes.
issue.
Yes.
Okay, and then also these also for the viewers out there, when you look at some of the new clauses, according to what the members of parliament want, amongst the recommendations is where a person employs another person as a casual employee for a period exceeding 6 months, the person shall at the expiry of the 6 months be deemed to have entered into a contract of service with the casual employee. If
the casual employee continues working beyond 6 months, is deemed automatically by law, an operation of the law will be
you're actively on a contract.
Yes.
Now, when you look at this, what specific industries or sectors will be particularly affected by these amendments?
I think the industries that are really promoting, that are using a lot of casual work in the undertakings, especially the manufacturing sector, but also the construction sector. The construction sector really uses a lot of casual, many casual laborers.
So it just comes and works for maybe 6 months.
Yes.
Until the site is done. If it's 1 year, they will still work verbally.
Yes, then the big, in agriculture, those big commercial
steel companies into industrialization and the sort. So there will be, but I think, do you think they are willing to adjust? Because I think by the cost, when you look at the cost of production in most of them, it becomes very hard. It does seem like they've not been protected in any way.
On the issue of enforcement, that is another thing, because when you look at, for example, the current Employment Act is not really entirely bad. It is deregulated, but still it has many protective provisions. But then when it comes to enforcement, it's another challenge, and that is really a big challenge. I wouldn't really talk about the costing, but also sometimes just a deliberate effort by the employers not to put certain measures in place.
Let's look at licensing of recruitment agencies that we have in the country here. Well, first and foremost, are they really recruiting people on in the professional way as it's supposed to be, or there is a lot that needs to be desired? Because when you look at some of the provisions in here, it looks like a person shall not transact the business of a recruitment agency in Uganda without a license issued by the minister. With Minister of Gender.
Okay, I was going to talk about that, because now with recruitment agencies, there are two things. Actually, there's majorly the amendment only talks about the ones that are doing external labor.
Yes.
But if you talk about the recruitment agencies as a whole, there are two folds to it. There are recruitment agencies that are doing both internal supply of labor within the industries in Uganda, but also externalization of labor that are placing workers, that are recruiting workers to go and work abroad. Now, what the amendment brings is more of bringing more protective clauses when it comes to licensing.
Okay.
Yes, and when it comes to enforcement, then that will also be another issue. It doesn't differ so much from the regulations that we had of the migrations of Ugandans working abroad,
okay.
Of 2005. But we didn't have like a comprehensive clause on labor externalization within the Principal Act. So some of the new things, for example, that the Act brings within the area of labor externalization is the requirement of due diligence for these recruitment agencies to first carry out the due diligence on the kind of employers that they're dealing with, that they are supplying Ugandans to. They should really know who are these, what are the safeguards. And also, the amendment also places on them a duty of repatriation. For example, if the contract has ended, then repatriate the person back first. And then, for example, in the event of death, still now it will be the recruitment agencies decide to repatriate the workers. Mm-hmm. But now, let's talk about these recruitment agencies. Now, whereas the amendment tries to bring those positives,
yes.
The amendment does not address the recruitment agencies that are doing internal supply of labor within the country. Mm. And when you look at the statistics of the current licensed
recruitment agencies,
yes, I don't think it even reaches 300. But in every locality where you go to, you're going to, yes, you're seeing a recruitment agency. But also with the internal supply of labor, we are having, for example, the HR solution firms, the firms that are doing HR functions. They're also doing, they're also acting, they're performing the functions of a recruitment agency. So within this amendment, I think a recruitment agency has to be extensively defined, just like there's already a standard, the ILO standard on private employment agencies convention 181 that extensively defines these recruitment agencies and their roles. Now, on the Ugandan labor market, the roles are not clearly defined. For example, we have recruitment agencies that just undertake interviews and they give you the workers and you retain, those workers are yours. When you like them, they become yours. You enter into an employment relationship with them. But now, what is now more common is that employers have realized, I think it is better for these recruitment agencies to carry out what we call temporary agents work, where you just, I just need this kind of work performed maybe for 6 months. Then the recruitment agent should just supply labor. I supervise that labor. It undertakes whatever, the labor undertakes whatever I want it to do. Mm-hmm. Then after 6 months, I tell them, please go back to the recruitment agents. So the recruitment agents enters into an employment relationship with the workers they supply, pays their salary, pays their NSSF. That's the arrangement. But they don't control what those workers do with the company they've supplied to. So there are those recruitment agencies doing that kind of work, but they're not regulated.
Yes. And
also the law, the amendment, the Principal Act does not address that, but also the amendment does not address that. The amendment focused more on labor externalization.
Okay. Well, after the break, when we return, we will be talking enforcement and compliance of these amendments. How shall we ensure that these particular employers comply to these particular amendments that have been mentioned as well? And also we want to look at more of the other provisions within the Principal Act, as well as those that are likely to be added into the new law once it is passed by Parliament and signed into law by President. And of course, after the break, we return with more discussions here on our Business Insight. Stick around. Good morning. Smart 24 driving business. Say goodbye to paperwork and travel costs. Now every MTN customer can register to invest in securities anytime and anywhere with Zabu in a few simple steps. Step 1. Dial *292 hash. Step 2. Select option 1. Register with Zabu. Step 3. Enter your full names. Step 4. Enter your national identification number. Step 5. Enter your national identification card number. In 24 hours, you will receive an SMS confirming your registration. Congratulations, you are now ready to invest. Smart 24, driving business. All right, we'll be back from the break, and many thanks for sticking around. For those who are still watching Smart 24 television, and for those who are just joining us, we are into our last half of our discussion, where our focus is still mainly on an insight into the Employment Amendment Bill of 2022, and of course, backdropping from the Principal Act of 2006 as well. But furthermore, our discussions here are on how much you as an employee will be affected, and how you can easily get a good view of the same act in here in regards to the provisions and the amendments that are likely to be made, hopefully by the end of this year. But of course, as you're watching and joining us, remember to grow your investments with the Zabu platform. Zabu is a platform that is powered by Altex East Africa, and Altex East Africa says do something new. *292# is the USSD code that you need to use to kickstart off your investment with the Zabu platform. And with the Zabu platform, the markets are open at 8:15 a.m. Mondays to Friday. Closing time is 3:15 p.m. They are only fully closed during the weekends and on public holidays. So as you kickstart off your week, remember to register with the platform, and all you need is your national identification number. After registration, in the next 24 hours, you'll be able to kickstart off your investment with just a minimum of 15,000 Ugandan shillings. So grow your investments with the Zabu platform, and then continue as much as you can. You can choose a preferred maturity period for the bond that you choose to invest in, and then you will see your investments grow. Zabu, my money, my future, Altex East Africa, do something new. Now we return with our focus on the Employment Amendment Bill of 2022, and I did mention enforcement. How will the enforcement and compliance of these amendments be ensured by the look of things? Okay, when you talk about enforcement, yes, there's one thing that comes into my mind, that's labor administration, because it's one thing to provide for the lawmakers to make the law, but also when it comes to enforcement of what is in the law, then that is an aspect of labor administration. Okay. And in labor administration, we are looking at two things: there's inspection, but also labor disputes, resolution of the labor disputes. Now, in the Principal Act, actually you raise a very important issue. In the Principal Act, we have a court of first instance, and that is the labor office, the labor officers. Okay. Now, with employment matters, whenever there's a grievance, a dispute, the first office to be visited by a worker or an employer, because these are two people in an employment relationship, is a labor officer. We have labor officers. Yes. I wouldn't say every district has, but every district is supposed to have a labor officer. Now, under Principal Act, the labor officer has many roles to play. Okay. A labor officer works as an inspector, but also is supposed to adjudicate cases, to hear and adjudicate cases and make awards, arbitrate, also mediate.
Now, in practice, there have been also challenges to that. Where, for example, a district has only one labor officer, and then you're having one of labor officer who is mediating a case, and at the same time, after when mediation fails, he ceases to listen. And legally, that is not tenable. You can't have one person mediating at the same when after mediation fails. Now you sit as a judge and you start listening and you make an award. Now, that has been a challenge. So I don't know whether this was the spirit of the amendment. Now, what the amendment brings is actually scrapping off the powers of a labor officer.
Okay. And
the labor officer in the new amendment is remaining with one particular power, only to conciliate. And conciliation is just an unbinding form of alternative dispute resolution, where you listen, you facilitate parties to agree. If they fail to agree, and it's voluntary, you can't force it. Now, that brings a fundamental issue now when it comes to enforcement. If this bill is passed in that form, and labor officers, their powers have been scrapped off, we are going to have a very big problem with compliance and enforcement. Why? Because that means that all adjudication cases, industrial court, which is a specialized court for workers, for labor disputes or workers' issues, is going to have a big, big backlog. And yet in the whole country, we have only 2 judges that are adjudicating, that sit on the industrial court. Now, labor officers, even with their limited capacity, have been trying at least to promote that labor access to labor justice in different districts. But if you're you're saying now they can only conciliate, and there's been also an issue where sometimes lawyers overlook these labor officers because some of them are not lawyers. They don't have a legal background. So they prefer, sometimes they even do that around so that mediation fails. You know, in the Principal Act, if a labor officer does not resolve a complaint within 90 days, so any party has freedom to further case to industrial court. Mm-hmm. So some lawyers have even been deliberately doing it because they don't want to appear before labor officers. Now, if that has been the situation, now when you scrap off their powers, that means actually most cases are going to bypass labor officers. They'll just be bringing to industrial court. And the industrial court already has a backlog. Like just last year, out of the very many cases, industrial court disposed of only 434 cases. Now, and we are talking about over 23 million working Ugandans. Now, you can't have a court with limited capacity of judges, and then you're saying these other labor officers who are like the first court of instance, like the way you see the magistrates. Yes. You're saying no, they shouldn't. Now they should just mediate. They shouldn't adjudicate. Of course, there's been that concern from the legal fraternity that maybe the competence, sometimes when it comes to the competence of the labor office, some of the labor officers are not doing their work as they're supposed to be, and they feel it's because they lack the legal qualifications. And I wouldn't really want to go into that direction. The issue of lacking legal qualifications to adjudicate cases can be resolved because, as I said, the law gives them so many powers. Maybe they would even categorize that, okay, this kind of labor officers, you can do inspection. Now, if you want to do, if you're going to be a labor officer who adjudicates, then you should have an extra qualification, legal qualification, but not even necessarily. They can be trained. They can be trained. They can be a requirement within the law for them to have a specialized training, maybe for 3 months on only adjudication. But the way it is right now, even if you have those very beautiful amendments coming, if you're scrapping off the powers of the labor officers to adjudicate, then compliance and enforcement is going to really not happen.
Okay. Well, and this brings me to the issue to do with the illicit or concealed movement of persons. There's a provision in here which says a person shall not facilitate the illicit or concealed movement of persons for employment abroad by organizing their departure, transit, or arrival of the persons in Uganda, or give assistance to any organization for the same purpose.
That's on trafficking or
of persons.
Yes, trafficking of persons. But you see, still, it comes to enforcement. The law is okay. The way it's providing, the spirit is okay. It wants to avoid individuals. First of all, as an individual, you're even not supposed to externalize someone to go and work abroad. It's the preserve of a company. A company that is registered, that has been licensed and given a permit. a permit to externalize labor. So individuals, what the clause is trying to provide is really to prohibit trafficking of persons. But we have also already we have even laws on trafficking, but enforcement, it is still it's an administrative measure.
I saw somewhere in regards to breastfeeding,
yes,
that
yes.
the committee therefore recommends that the Employment Act of 2006 be amended to provide, one, for the obligation of an employer to provide time and space for an employee for the purpose of breastfeeding their child, then B, establishment of a breastfeeding facility
yes.
at the workplaces.
Yes.
When you look at some of these provisions, some of these amendments, I should say, or some of these recommendations rather, setting up a facility for breastfeeding, wouldn't it be too harsh or too costly for some of these particular companies in the country? You know, because there's some companies who have facilities that can at least cater for such. But given a situation where a business is, too small, having maybe 30 employees, and, the place where they're working from is really squeezed, doesn't it look so harsh for them?
It might look harsh, but again, also the spirit of that provision, the spirit is in good faith when it comes to promoting the labor participation rate of women.
Okay.
Constitutionally, by the way, there's a constitutional provision that places a duty on Parliament to make laws that protect a woman worker, that places an obligation on an employer to protect a woman during the pregnancy, but also after. So the current act only provided for maternity protection of 60 working days, but it didn't provide the provisions of nursing care, and this has also been. This is one of the requirements in the international labor conventions, especially for promoting the rights of women at work. Definitely, this has a financial implication, especially for the small businesses. But then it's in a good spirit. It's in good faith to promote, to facilitate women to actively participate in the labor market without having this over the burden of the care work. So generally, it would have been proper if government can maybe subsidize or also show commitment on how they're going to help the employers to do it. Because as you know, yes, we have the big employers, but even actually there are big employers who will not even really see that as a viable, really a feasible measure when it comes to their economic setup. But then if it's put in the law, it will be an issue of compliance, whether they really have the means to put in place that. And when you're talking about that, we also have now, we are blind to the fact of the informal economy, where there are enterprises that are also having informal workers. Like we have unregistered enterprises or informal enterprises, but still employing people in informal. So can those ones really afford that? That is a question. That is a question that needs to be debated on. But then the provision is good. It's a positive step. It's a positive direction towards the protection of women at work.
Okay. By the look of things, how does this employment amendment bill align with some of the broader labor market trends that are evolving in regards to the nature of work that we're having here? If you're to compare with the other, broader labor market trends.
Yes, I would still say that the current amendments actually even comply with international frameworks and in different countries.
Yes.
For example, casualization in most of the countries is really being, there's a way it's not promoted. There's a way the law actually tries. One of the things, for example, if the government is looking at formalization, the first thing to formalization is recognition and protection. How much more are we even losing if the government actually even cared? How much more would government, is government losing through casualization? Because if I'm getting money under an informal arrangement, there's no way URA is really going to run after me. But if workers are under formal arrangements, the government domestic revenue increases. Under Europe, in Europe, there are so many directives that regulate, for example, certain kinds of work, and all those directives are geared towards making sure that these the formal enterprises continue having a biggest percentage in formal kind of arrangements, not informal. For example, I talked about temporary agency work outsourcing. The European Union has directives to regulate. Of course, these are the directives. These directives are not there to protect only workers, but they promote labor flexibility, but at the same time also protect workers.
Yes.
So, like for example, with agency work, the EU directive on temporary agency work, first of all, clearly defines parties in a relationship. It says, okay, you, the recruitment agency, yes, you're retaining a relationship with this worker you're supplying, but make sure you pay their wages on time, make sure you pay their social security, and also when it comes, for example, to a worker getting an accident at work, then the directive also specifies who among the employing entities should be liable. When it comes to issues to issues like union rights, because you see also that this kind of casualization and also these new forms of work, if they're not regulated, there's a way they prevent workers from enjoying their union rights, like to join or form a union, and also because how can trade unions organize such workers who are being placed from one entity, then they're taken here, and then there are these ones who are employed by word of mouth, and most employers don't actually want their workplaces to be unionized because they don't want workers to have power. So if I employed you by word of mouth and I realize you've joined a union, you sting up a union, I'll just chase you. Because
I'll stand up for my rights.
Yes. So these directives are actually in compliance with international law. They're in compliance with the most of the conventions, the fundamental principles at work. Okay. But also, like, you're talking about the global trends. Also, for example, the OECD guidelines. We are having many multinational companies here that are benefiting so much from cheap labor and all our low labor standards. And yet, actually, they are coming from countries that are members of the OECD. And yet, their guidelines, the OECD guidelines, put an obligation on them to provide even better standards in countries where they are working. For example, if a multinational company finds that the Ugandan labor standards are very low, or they still have a duty to promote the better labor standards under the OECD guidelines that bind companies that are coming from different countries that are members. So I don't really think these amendments are going to hurt them in one way or the other, because even under international framework, they're under duty to promote fair labor standards, fair labor practices.
Okay. And as we are summing up with our conversation this morning, what are some of your parting shots, but still in relation to the same?
One of the things that comes out clearly is that the spirit of this law, it really seeks to address casualization, though the conceptualization of also what amounts to casualization has not really been defined so much. So, for example, if you're saying the cure to casualization is offering a written employment contract, there's still a lacuna there, because I can be given an employment contract of 2 weeks, renewable. I can be given an employment contract of 1 month, renewable, but everything is documented. Does that put me as a worker in a much more better position? Because since COVID now, COVID also brought its own dynamics on the labor market.
Yes.
Yeah, where employers became wiser and said, oh, okay, because during that time, COVID affected everything, and there was that process that you don't just lay off people. You have to do this, give notice, pay notice. Now, what happens after COVID? We have had the rise of fixed-term contracts, written contracts coming, but they're not regulated. Whereas they're regulated in other countries, here they're not regulated. So if you're saying the cure to casualization is a written contract, but then you've not actually regulated also fixed-term contracts, then it doesn't really make sense. I can give my worker a written contract of 1 month, renewable, and doing away with a fixed-term contract is very easy. I may just be patient a little bit. I wouldn't give even, I am not under duty to give you a reason. I'll just wait for it to expire, and I tell you, I notify you that your contract is going to expire and I will not renew it. And now you can't say I have unfairly terminated. You can't say I haven't given you a hearing, because under the law, of course, expiry of a contract is one of those justifiable reasons. And so it has that trend. I still feel, though there are employers there who are already worried because you're supposed to give someone a casual, a written contract after 6 months, but still there's still a lot to be desired. Fixed-term contracts are not regulated, and yet actually those casual terms can be structured in a contract.
Okay.
Yes.
And of course, as we're coming to the end of our discussions, I don't know what you feel as a viewer out there in relation to our kind of discussions here relating to the Employment Amendment Bill 2022. Of course, you really need to follow up on most of the things, especially the employees and the employers, because at the end of the day, you get to realize they directly impact you or indirectly impact you if at all you do not follow up on the same. Many thanks for joining us this morning, and thank you for sparing your time. That is Ms. Kagoye Robina, who is the Executive Director, Voice for Labour. Of course, we were discussing huge insights into the Employment Amendment Bill of 2022, and at this time, as we're coming to the end of our discussion, only to remind you to grow your investments with the Zabo platform, because Zabo is here for you, and it makes it very possible to invest in government bonds and other securities. *292# is the USSD code you need to use for the MTN subscribers. To kickstart off your investment, register with your national identification number. The markets on the platform open at 8:15 a.m. and closing time is 3:15 p.m. East African Standard Time. You should note that these markets are fully closed during the weekends and on public holidays, but the rest of the days you are able to kickstart off your investment and grow your investments with the Zabo platform. Zabo, my money, my future. Altex East Africa, do something new. It is a brand new week from us to you. Of course, this is another tight one for most of the parents who are taking children back to school. Not only that, it's still the same week where Catholics and the Anglicans are joining in the Christian faith to celebrate the Martyrs' Day that will be taking place on the 3rd, which is Saturday this very week, 3rd June 2023. And for the business community, we are here to make sure that we guide you through with information that matters most. But also, if you want to follow us on our socials, Twitter is Smart24TV now. Same applies to our Instagram. But also remember, our YouTube channel is Smart24TV. Please remember to subscribe and get notifications in regards to business updates and business interviews, plus other insights in relation to business, of course. And if you want to watch us anywhere, anytime, remember to download the smart, the smart digital app. This particular one will help you stream all our networks, including NBS, Codeo, Smart FM, and Smart 24 television. The website is www.smart24.tv/news for both local and international news updates happening in real time. I'm Joram Paul Sonko from the entire team. We do wish you a good day. Till tomorrow, good morning.